Hello, well here I am at Windmill Animal Farm and we're going to have a look at some sheep whilst we discuss the case of Pennington and Waine within the area of constitution of trusts, because of course Lady Justice Arden mentions tempering the wind against the shorn lamb in the case. So let's go and have a look at some sheep and hopefully some lambs. So here we are at Windmill Farm, having a look at some various animals. We'll look at some sheep first, as I said in my introduction, because Lady Justice Arden does talk about the idea of equity tempering the wind against the shorn lamb. So we'll look at some sheep of various descriptions, various breeds that there are here at the Windmill Farm, this rare breed farm. But we'll look at some other animals as well, perhaps as I discuss the case that we're here to discuss, which of course is Pennington and Waine. So Pennington and Waine, which is 2002 square brackets, 1 Weekly Law Reports at page 2075. This is a key case in the area of constitution of trusts, formalities, and the passage of property. And of course, it's a key case in our continuum of cases that we're highlighting in these equity shorts from Milroy and Lord, Rose, and then finally here, Pennington and Waine. It's also a noteworthy case because not only does Lady Justice Arden use this evocative phrase, tempering the wind against the shorn lamb, it's also noteworthy because the first instance decision was, of course, in Liverpool, and it was Judge Howarth, who is sitting as a judge of the Chancery Division in Liverpool in the civil courts, who made an order on the 27th of October 2000 that is noteworthy. So, let's have a think about this case, and in particular, again, the species of property that was involved, namely share certificates relating to shares. And it was 400 shares in a company called Crampton Brothers that were the subject matter of this potential trust or gift that we're dealing with. And of course, we're mulling towards the idea in this instance of a gift. So the facts are this. Mrs. Ada Crampton, she wanted to transfer 400 of her shares in Crampton Brothers Coopers Limited to Harold Crampton Jr. So she wanted to transfer by way of gift to her nephew Harold shares prior to her death. This was because in order to be a director of the company, the Articles of Association required that a director, in this case Harold Crampton, held at least 1 share in the company. So the constitution of the company meant that a director must have shares in the company. This is perhaps therefore why Ada Crampton wanted to pass property to Harold. So Ada signed a share transfer form and the company's auditors wrote to Harold to inform him of the share transfer and asked that he complete the prescribed form of consent to act as a director. Harold, of course, then signed the form and it was then countersigned by Ada. Then the signed share transfer form was retained by the auditors but was not sent to the second defendant, that's to say Harold. Well, subsequently Ada dies, and in dying she left a bit of a problem. And that's because she executed a will. And in that will, bear in mind she's just purportedly gifted some shares to Harold. But in the will, she makes specific gifts in the will including the balance of a shareholding, but she makes no mention of the 400 shares. So what we have then is a battle for value, because when she died in November 1998, Harold Jr. was potentially a gift recipient of those shares that we've discussed, those 400 shares in Crampton Brothers Coopers Limited. Whereas ranged against him in terms of potential recipients pursuant to a will were Jack Pennington and John Breen. And that's because they were the executors of the will. And within that will, there were, as I've already said, potential gifts and other residuary beneficiaries who were interested in whether or not there had been a valuable, equitable transfer of the shares to Harold. Because if there hadn't, then of course those 400 shares may still form part of the estate of Ada and therefore be distributable amongst those will recipients. Well, this question goes up before Judge Howarth, as I've already said, in Liverpool, in the Chancery Division. And he said, or he held that the gift of 400 shares did become effective when Ada executed the share transfer form, and that there was no legal requirement for the form to be delivered to the donee or to the company. So in this sense, Pennington and Waine, at this stage anyway, at first instance, is very similar to the outcome in Re Rose, that which we've seen earlier. Very close in terms of this point about filling in the relevant transfer document is enough for the donor to do in terms of formalities. And ergo, since the judge had held that since Ada had transferred the whole of her beneficial interest in the 400 shares to Harold, she'd rendered herself and her executors bare trustees of the legal interest. So the gift of 400 shares became effective when she signed the transfer form, and then therefore there was no requirement for the form to be delivered to either Harold or the company in order to make the gift complete. Excuse me. This differs slightly from Re Rose in that we know that in Re Rose there was a transmission of the share certificate transfer form and the share certificates to the company. But this steps back slightly from that as Judge Howarth's first instance judgment. It gets appealed and goes up to the Court of Appeal, who in this instance are Sheeman, Clark, and as I've already said, Lady Justice Arden, who gives the main judgment, and they dismiss the appeal and therefore hold that Ada had plainly intended to make an immediate gift of the shares to the second defendant, and he had become a director because of this activity. In other words, without the shares being transferred to him, he couldn't become a director. And anyway, in the circumstances, it would be unconscionable for Ada to recall the gift. Well, let's mine the judgments. Let's have a look and see what the respective judges said. In particular, let's focus on Lady Justice Arden and this evocative phrase, because it was Lady Justice Arden who divided up the ways in which the courts have assisted volunteers into three ways. So, as we know, where a transaction is purely voluntary, normally the principle is, of course, that equity will not assist a volunteer, and that principle should be adhered to. In other words, if there's a voluntary passage of property from A to B, but in some way B thinks that passage hasn't been done properly, equity will not step in. That's because, of course, we're trying to encourage A to do things properly, to constitute trusts or transfer property pursuant to a gift in an effective, proper way, using the proper formalities. But Arden, of course, Lady Justice Arden opines that there were 3 areas where the courts have attempted to protect the shorn lamb, that's to say the recipient, from the wind of uncertain gifts. The first is this, that if there's an incompletely constituted gift, it could be upheld if the gift had been completed to such an extent that the donee could enforce his right to, for example, shares as against third parties, without forcing the donor to take any further step. In this instance, we might identify re-rose as an example. The second area, where equity has perhaps worked its magic, again, we can use re-rose as an exemplar, because on occasion equity has tempered the wind of the principle that equity will not assist a volunteer to the shorn lamb, the donee, by utilising, of course, the constructive trust. And then the third area of equity or approach that Lady Justice Arden identifies is benevolent construction. That's to say that the courts, in approaching these kinds of activity, will construe it as if that which is done ought to be done in terms of a matter of construction. So they'll try and bring a benevolent construction. So then, therefore, the basic principle underlying all the cases, we might argue, is that equity will not come to the aid of a volunteer. So if a donee needs to get an order from the court of equity in order to complete his title, he will not get it. However, on the other hand, if the donee has under his control or her control everything necessary to constitute his title completely without any further assistance from the donor, the donee needs no assistance from equity and the gift is complete. Well, there's been some critique of this decision, most notably by Oakley in Parker and Mellows, another Liverpool connection there, of course. Excuse me, and that's because he said that this is a misapplication of the Lord Goff's approach in Choithram. That's to say, when we think that although equity would not aid a volunteer, similarly would not strive officiously to defeat a gift. So according to Oakley, Lady Justice Arden seized on the wrong element of Choithram, as the donor had neither made a trust or made a gift or done everything she could to make a valid gift, i.e. transfer the document to the relevant office holder within the company. So, as Oakley says, the Court of Appeal's decision contradicts every single previous authority, including all the cases in which the decision in re-rose has been applied. It is therefore suggested that Pennington and Waine was wrongly decided and should not be followed. So that's Pennington and Waine, and that's a way of considering formalities in relation to shares, what needs to be done to cause a valid gift. And similarly, it's a good authority for us to try and critique using that secondary source of Oakley. Well, whilst I've been talking about the case, I hope you've enjoyed the view of the Windmill Animal Farm. And so from here, with that case in mind, I bid you goodbye.